Hey, I'm Denise Howell, and you're tuning in for This Week in Law. And on our last episode of 2013, we're going to take a little ride along with Larry Downs and Julie-Ahrens. We'll talk about Julie's successful fair use case. We'll talk about online car services. We'll talk about safety, online reviews, lots more next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown. Episode 240, recorded December 20, 2013. Barnacles, Blackouts, and Blue Ribbons. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law, where we talk about the heady issues that occur when technology and the law collide. And we've got a great panel today to wind up our 2013 batch of episodes. It's going to be our last episode of the year. So we're very excited to go out with a big bang with Larry Downs, author, columnist, political and policy analyst, teacher, man about the internet, and most currently author of Big Bang Disruption, available at bookstores near you and, of course, online. Hello, Larry.
Denise, thank you for having me back. Thanks for the shameless plug. The book actually doesn't literally come out until January 7th, but pre-orders are available now.
Good. That's what I meant. Get your order in. It's going to go fast, like gingerbread cookies flying off the shelves at this time of year. Also joining us, taking a break from her holiday travel, and I'm so thrilled to have her back, is Julie-Ahrens from the Center for Internet and Society at Stanford. Hello, Julie.
Hi, Denise. Thanks for having me.
Great to have you back on. Also joining us, of course, is my co-host, Evan Brown. Evan, good to see you.
Yeah, Denise, happy holidays. It's been a great 2013, and what better way to end it up than by talking here on this Friday afternoon. Should be a good time.
Yes, I'm really excited to get into it. I was excited to hear from Julie yesterday that there was some good news in a case she's been involved in for some time. So that involves the entertainment industry. So let's go there and talk about that first. So if you want a refresher on the NFL's Baltimore Ravens fair use case, go back to episode 210 of Twill when Julie previously joined us. We talked about the case a lot then. That was back in May. Now they've gotten a decision. Julie's the Center for Internet and Society was not directly involved in the case. I believe that's true, right, Julie? You guys don't directly represent a party, but you have filed amicus support?
Right, that's right. Yeah, we filed an amicus brief on behalf of the International Documentary Association, FIND, which is an independent filmmakers organization, and the Motion Picture Association. So the MPAA are three people that we were representing as amicus parties.
Right, and the interesting thing about that is the issue at stake is fair use. And sometimes it takes a big entity like the NFL or the MPAA to make a decision that, I sort of traditionally think that fair use is the province of the people. The little guy needs the fair use doctrine to be strong. But this case shows that the big guy needs it to be strong too, doesn't it?
Sure. Yeah, it definitely does. And the other great thing about this case is that, even though as a big guy here with the NFL, probably surprising people maybe that, our organization might need to weigh in on behalf of the NFL. I think what was important here was that the ruling in this decision, would affect obviously the NFL and how the Baltimore Ravens could use the logo that was at issue. but it also, would set a precedent that could be potentially, if it goes the wrong way, could be potentially really harmful for the little guys, the independent filmmakers, the people who don't either have the money to pay licenses for all of these kinds of uses or hire lawyers to figure it out, or to fight another lawsuit if it comes down the pipe for these kinds of uses. And the case involved using, a historical logo that was the Baltimore Ravens' old logo in the beginning seasons of their existence back in Baltimore from 1996 to 1998. And so, using historical artifacts in new creative works is a really fundamental thing, particularly for documentary filmmakers. So the case raised really important issues that affected a lot more than just, the NFL and the particular facts of this case.
So how did the court struggle at all in reaching its decision, finding that fair use applied and the documentary film's use of the logo was okay?
The court reached a unanimous decision here, but what was actually potentially troubling was that this case has been going on forever, and this was actually like the 5th time it was appealed to the 4th Circuit on different facts or different issues. And what had happened was that in 2010 there was a ruling against the NFL when they claimed fair use of using this historical logo in highlight films that they were showing at the stadium during the games. So there, the panel on the 4th Circuit ruled that was not a fair use because they were basically re-showing games that had happened in the 1996 through 1998 seasons when the Ravens used this logo that was found to infringe the plaintiff's copyright. And so what was potentially troubling was the scope of that 2010 decision, which, we actually strongly disagreed with that decision. But then these particular uses, so basically the plaintiff won in that, Bouchot won in that case in 2010, and then went back to the district court and started suing about every single time the NFL has used this logo in any of their historical footage or in their stadium displays. And so, this case was important to kind of rein in the scope of that 2010 decision. So here, the court didn't seem to struggle too much, although, they had some questions about commerciality, and, that kind of stuff seemed to, concern them. But, it was a unanimous decision and very strongly in favor of fair use.
I'm curious how Bouchot, obviously this case, and Evan was just reminding me before the show that this case has gone on for a really long time. I'm curious, though, if we unravel it back to the beginning, how Bouchot wound up with the right to even bring the case. I understand he created the logo, but presumably the NFL is not clumsy about getting its licensing ducks in order.
Right. Yeah, this was one of those cases, you see all the time in copyright law, particularly with film industry, where somebody says, hey, I submitted that drawing and it became part of what they actually used to make their logo. So it wasn't like he was I think he was like a security officer or something, and he had access to some people at the Baltimore Ravens organization. And so there were facts that, showed that he had made this drawing, and the court found, way back in the very beginning of this litigation, that the logo that the Ravens actually went with was strikingly similar or whatever to his drawing. So it was one of those cases. So it wasn't strictly they just forgot to license.
Right. So it wasn't like he was doing work for them and revoked the license or some such thing.
Exactly.
Wonderful. So can you flesh out what does the court's decision mean as a practical matter for let's start with documentary filmmakers and then other filmmakers and sports teams.
Sure. Yeah. What was really great about the decision that the court just issued this week was, they went to great lengths to recognize why fair use is important for filmmakers, and particularly using historical what we call historical artifacts, things that are happen to be copyrighted, but they are, necessary to telling an accurate and historical story. So here, because of the facts of this case, Bouchat was never, even though they were found to infringe his copyright, he wasn't given any damages. So all he was seeking in all of these cases were injunctions. So what he wanted to do was enjoin any use of this. And so, that, very clearly becomes, either a clear, ability to censor what's in these films, or to, hold them hostage until they pay such a price that he could do it. And so what the court recognized was that, copyright shouldn't be used to hold historical facts hostage, so to speak. And that's really important. It's a really important principle for filmmakers, one that has been well recognized in lots of decisions and lots of circuits. So why we thought it was really important to jump in was to be sure that the apple cart wasn't upset, and that something that filmmakers have come to rely on as, kind of established fair use, limited, within context, very specific transformative uses of copyrighted material to tell a historically accurate story, is something documentary filmmakers in particular have to do all the time. Often the best way to tell your story is to talk about either the words that were written at the time, or the film, or a photograph of the time, or something that actually lots of times proves what you're talking about or proves your argument. So it's a really important thing that filmmakers rely on, and that, in the wrong circumstances, the fact that somebody owns a copyright over a piece of history can really gum up the works and keep them from being able to tell the stories they need to tell. So, the victory here was really important for reaffirming, I think, that using that stuff is a legitimate fair use.
That's making me feel all warm and fuzzy based on what was going on the Twit network just before we started This Week in Law.
Oh, yeah.
From time to time, we definitely will look to some historical artifacts to illustrate a point, or help the audience understand, put something in context, etc.
Right. Exactly.
So it's good to know. Yes. Larry, you were involved in, you were a non-resident fellow at the Center for Internet and Society at Stanford at one point, weren't you?
I was, yes.
That's great. Do you have any questions for Julie about this decision?
Well, I was listening to Julie, and there's no question, this is a good decision. It's a great decision, and it's the right decision. I was thinking, this is your 240th episode. This is probably the 240th time you've talked about the fact that copyright is probably the most important area in which technology just has gotten ahead of the law. And we're tinkering with the edges of this here. But the bottom line is, as I'm sure is not surprised to anybody, copyright just isn't working in the digital age. And this is a great example of it, because I was thinking, well, how many people would this have affected, say, 20 years ago, who had access to make movies or make videos, and also had a distribution network to show those movies and videos? And you think 20 years ago, it was very expensive even to have a home video camera. Of course, you couldn't edit anyway. You couldn't make a film. And you certainly didn't have things like YouTube and other services to distribute that film. So this, would have been a problem for a very, very small number of people. Now, of course, it's a problem for everybody, because, we're all making videos and we're all distributing the videos. And it just highlights again how messed up the law of copyright is in the digital age. And I think particularly, in fair use, this is the one edge in which it's the most troublesome and the most difficult. And of course, the court, had to rule this way, as Julie said. But this is by no means the end of our troubles. As we get better technology and the law doesn't change, we're just going to have more and more of these kinds of difficult conflicts.
Yeah, I think it's really important to bear that in mind. And you make an excellent point, Larry, that issue does come up on every single one of the shows that we do. There is a great decision from the Fourth Circuit on this, and CIS's write-up of the case and what it means in our discussion points at delicious.com/thisweekinlaw/240 if anyone wants to dig deeper on this. Evan, any thoughts before we move on?
Well, if we're going to move on, it's probably a bad time to bring up the First Amendment because there are no short discussions about that. But
we don't have to move on. Let's bring up the First Amendment.
I really like Tim Green's write-up on the CIS page about this. And I don't know if this is actually in the opinion, but Tim talks about this. And Julie, I hope you can comment on this, about how the Fourth Circuit's opinion deals with the problem of private censorship, and it's the concept of private censorship. I don't know if the Fourth Circuit opinion actually uses that term, but we all know what we're talking about when it comes to that. And I guess I of course agree that this is a right decision, and the cultural content of copyrighted works is something that's very near and dear to my heart. I like to look at history with the long view, and it's a very big tragedy to the extent that copyright can lock something up, or DRM could lock something up, so that periods of history are missing. Harkening back to what we were talking about with Professor Heald last week on all of this stuff. But I want to be able to articulate in a good way, and Julie, maybe you can help me articulate this and not just gloss over this idea of, if a private plaintiff is seeking to enforce a copyright right, and a court comes back, as it did in this situation, and says that it is a protected fair use for the documentarians, the filmmakers, the NFL, whomever else, to use this content because it was a protected fair use. How do we make sure that we're not conflating two things, or, like I said, glossing over things in a way that doesn't do the legal analysis justice to say that the First Amendment can come in and affect what one would characterize as private censorship, because we all know that the First Amendment deals with government restrictions on speech. A&E is perfectly within its rights to do whatever it wants with the characters on Duck Dynasty. That's not a First Amendment issue. How is it? How can we talk about that intelligently? This private censorship and First Amendment concern.
Yeah, I think that's a great point. I think where the First Amendment, kind of, when you think about what is a First Amendment right, it is, obviously, if you start with the fundamental principle that we have, free speech rights, then copyright is in and of itself taking some of our free speech away, right? So it gives people exclusive rights to control content or control material, which is a way of saying, you don't have the free speech, to do this. So fair use is that provides that, what we call the lubricant between those two tensions. So the tensions of, we all have First Amendment rights to speak and make our arguments and use whatever speech we have, and cultural discourse, et cetera. Copyright comes in and covers some of that. There is some overlap there where copyright will affect your ability to, you have, certain amount of speech, and fair use provides that intermediary kind of protection, so that copyright doesn't, so that copyright doesn't offend the First Amendment, basically. So, the Supreme Court has said in several cases, that the fair use is a fundamental First Amendment safeguard to ensure that copyright, that the copyright laws are not infringing the speech. And so as far as the private actor versus the government, the point is that the private actor can go to court and have the court enjoin your speech. So there's the, government acting and why you have a First Amendment right to say it anyway. Does that make sense?
Yeah, it sure does. And that's what I was thinking. I mean, as long as you're getting the court and its judicial power in role, that's when the government, right. When the restrictions on the government under the First Amendment comes into play. That's what you're saying, right?
Yes, exactly.
That makes sense. Yeah, that makes sense.
All right. Well, since we're going on in a sports vein here, it looks like sports fans have some reason to be thankful to the FCC, which Wednesday this week proposed repealing its blackout rule. Larry, tell us about this.
I'm sorry I put this up. I thought this was an interesting story, and then the more I read it, the more I realized It was one of these incredible FCC quagmires. So there's been a blackout rule since the mid 70s that says if 72 hours before an NFL game, or sorry, any major league sports game is about to take place, if the tickets haven't been sold out, then the game cannot be broadcast over the air or on cable and satellite. I don't remember now anymore. I was kind of young in the 1970s. Who asked for this and why it was made part of the FCC? I mean, you'd think it could have been just a contractual agreement between the broadcasters and the sports leagues. But of course, the bottom line is now it's kind of a laughable rule in almost every sport, certainly in football. The idea that a game isn't going to be sold out and that somehow if we put the show, if we broadcast the game on television, that's going to mean people aren't going to go to the game. The two are such completely different experiences. And of course, in that intervening however many years, the revenue stream has changed so much from, teams actually making money from people going to the game. Now, of course, they make all the money from television and licensing and merchandising and all the other rights. So on the one hand, it's clearly a rule that's outlived its usefulness, if it ever had usefulness. And all the FCC, by the way, here is doing is proposing. They've initiated a rulemaking to undo it. So they haven't said they're going to undo it, but they're essentially starting an investigation into whether it's still useful or not. The problem is the NFL's actually gone on record saying they oppose removing the blackout rule. If you try to understand why, you start to get into several other related FCC rules and procedures and doctrines, including retransmission consent and must carry, and the difference between their relationship with over-the-air broadcasters, which are regulated one way, and cable and satellite broadcasters, which are regulated another way. So it sounded very simple, and I think what it actually winds up highlighting is that it's always a big mistake when we insert the regulator, and particularly in this case the FCC, into a business that's changing very quickly, because that rule from 1975 doesn't make any sense anymore, but it's been barnacled with so many other and attached to so many other rules that unraveling it now turns out to open, I'm mixing a lot of metaphors here. It's unraveling the barnacles is opening a Pandora's box. I think is the collection of metaphors I want to use here. And what's going to happen is it's going to turn out not to be anywhere near as simple as it sounds, because all these other parties, the broadcasters are going to have one set of unrelated issues. The cable and satellite people have their own. The networks are going to have their own. There's going to be differences between baseball and football because, of course, a lot of times the baseball teams are often owned by a local over-the-air broadcaster. So that, that gets into ownership rules, which the FCC is also looking at changing. And so a story that I thought was simple turns out to be simple, but in another way. And that other way is to say, we should never get the FCC involved in these things in the first place.
And this doesn't affect all those other separate agreements between the leagues and that have to do with, if you're carrying this game, you're not going to be able to carry this game. This only has to do with whether a game that hasn't had a certain amount of ticket sales can be broadcast, correct?
Yeah, it was a what we call in law bright line rule. It said 72 hours, no broadcast, and it essentially forbid the parties from contracting in a way that somehow they wanted to be bound not to be able to make certain decisions. Now some of those parties are unhappy about that, but not all of them. But yeah, it doesn't affect all the other complicated rules about who gets to broadcast what and when, because of course it's still the sports game is still a private event, and you can decide who and in what capacity you're going to allow taping and broadcasting and other kind of commercialization of it. The question was just, whether or not you were going to put the FCC on top of certain parts of those contracts saying, no matter what you want to agree, this is one thing you can't agree.
All right. Well, we appreciate being brought up to speed that this is going on, even if it is an FCC quagmire. And I appreciate the fact that I'm going to be able to make Unraveling the Barnacles our first MCLE passphrase for this episode of This Week in Law. If you are listening to this show and are a lawyer or another kind of professional and you think that getting some professional credit for listening would be something you'd be interested in, go to wiki.twit.tv. We have a page there that will give you lots more information. And we put these passphrases in the show in case you need to demonstrate to some sort of oversight body that you actually listened or watched the show. Evan, so do you think this is going to impact sports fans at all?
Well, I don't know. I mean, it's interesting to see how the rationale for the rule translates into modern life, because, clearly, as Larry pointed out, the revenue streams for sports teams is different now than what it was back then. Back then, it was mostly ticket sales, and now it's merchandising and everything else. And so the revenue streams that professional sports enjoy now is separate and apart from, actually being there in the game. And so you wonder, you kind of, one is left to further ponder how the rationale would play out now if, and how professional sports could still thrive and still be something enjoyable and still be revenue generating for the league and the teams, even if no one ever showed up at the arena or the wherever it's being, the arena, the stadium, wherever it is, the ballpark. But I guess there would be something inherent missing from that, the actual excitement of having tens of thousands of people in one place. But it just goes to show that, it is sort of upside down, and there are things that need to be unraveled from this set of barnacles. And I think somehow the metaphor could also involve weeds having grown up in there as well. So who knows what professional sports would look like in 10, 15, 50 years from now.
Yeah.
All right. Well, go ahead, Julie.
Oh, I was just going to say, I thought, wasn't there a big, talking about how technology changes and it makes a difference. I thought there was a big stink not too long ago that teams were really worried about the stadiums because of TV broadcasts and everybody's home televisions being so much, such a sharper picture and so much better that they would never need to go. I mean, it might be fun to go to a football game, but, having grown up here in Ohio and knowing what it's like in January, I can't imagine. Some people are like, oh, we can watch it at home, even if it's not sold out. That'd be great. It's just a thought that occurred to me about why they maybe cared about, keeping this rule the way it was.
Yeah, and you certainly don't go to a game, any professional sports game, perhaps, maybe unless you're on the front row, which is obviously the very small portion of people. You certainly don't go to the game to get a better view of the game with high definition and instant replays and, the visual aids that are helpful, like in football where the line of scrimmage is, the blue line and the yellow line for the first down. It's so much easier to actually take in the information of the sporting event if you're watching it from the comfort of your home rather than being there.
There was actually a story on NPR this week that I guess there's a big fight going on between the Seattle Seahawks and the Kansas City. All right, now I've just exposed myself as a terrible football fan because I can't even think of what the Chiefs. Thank you. That they're having an ongoing battle with the Guinness Book of World Records people about trying to set the record for loudest decibel screaming among fans. And the Seahawks got the record, and then the Chiefs a few weeks later exceeded it by 0.10 decibels. So now the Seahawks are getting it back, and the point is that you don't go to the stadium, as Evan says, you don't go to see the game. You go for a completely different experience, and that's it's in some ways it's a separate product or separate service. The two don't really need to be tied to each other anymore.
Well, and I guess there's a copyright gloss on this too, possibly. That comes into the economic considerations we were discussing around whether people are at games or not. And Julie mentioning, the whole high definition TVs at home and the home viewing experience as being a factor. But then there in the stadium, a different factor would be all of the HD cameras that people are carrying with them and the ability to stream what's going on and, circumvent the NFL and ESPN and all the other outlets that add their own gloss to the games. And, maybe they're just streaming to a small number of people or a large number of people. Of course, it's prohibited, but that doesn't mean people don't do it. And it certainly would discourage people, I guess, in theory, from going to the games if they knew they had a friend there on the 50-yard line with great seats who was going to stream them the action. Do you think that factors in at all, Larry?
Well, as you say, in theory, I don't think, the reality is apparently we can't get enough sports in this country under any circumstances. Whatever technologies we've got, we're going to use all of them anyway. And so I can't imagine that they're losing a whole lot of revenue from people streaming their HD cameras from the 50-yard line. It's possible, and I'm sure there'll be litigation if there isn't already. But I just hone to the view that there's no such thing as too much publicity. And, the more people who are watching and the more different media, somehow, that quickly translates to higher revenue one way or the other.
There was some silliness along these lines. I think it was back in 2008 or 2009 in college football. I remember the SEC, not the Securities and Exchange Commission, said that, it tried to ban all use of social media at the football games. And, the stated fear was that people wouldn't watch the game on TV because they were following somebody on Twitter, giving a play-by-play, silly. And I think that was short-lived. I think that ban was lifted maybe even before it had a chance to begin. But it's another demonstration of that concern, at least in the early days of 2008, 2009 of social media, of, this concern of circumventing the ordinary distribution channels for the content.
Yeah.
There was a famous case in the 1980s, I think in the 1980s, involving maybe early 1990s, involving a Motorola device called the Sports Track, which was kind of a pager. So this was pre-smartphone era. It was like a pager, and it would send you up to the minute statistics about a game. And this was the NBA in this case, sued and said, that was a copyright violation, essentially that they were violating the copyright in the game itself. And the Second Circuit, if I'm remembering this correctly, said, no, those were facts. They weren't part of the creative expression of the game. And the Sports Track was, of course, allowed to die because it was a bad technology, not because it was an illegal technology.
Yeah.
All right.
Sorry, that's just another example of, trying to use the copyright, to kind of lock down facts or information. The Second Circuit rightly decided that is not the scope of copyright protection.
All right. Well, from copyright to privacy, lots of developments on that front this week. So let's go there next. So it's happened. We knew that this shoe, that lots of people have been hoping this shoe would drop, and there are lots of lawsuits that have been pending seeking this result, and the result came down in a district court in Washington, D.C. This week, which found that the NSA surveillance program is likely unconstitutional. Judge Richard Leone found the bulk telephony metadata collection and analysis almost certainly violative of a reasonable expectation of privacy. So almost certainly leaves a little wiggle room, but it is definitely certain that the DC Circuit will next get a crack at this, because the order is stayed pending the appeal, and it certainly will be appealed and will perhaps make its way up to the Supreme Court on the constitutionality of the surveillance programs that have been so in the news over the last several months. So what do we all think the significance of this first decision is? Larry, let's start with you.
All right, so I have to start by throwing cold water, which I, regret, because I'm, of course, in agreement with this decision. But as you say, Denise, it is a district court decision. It does not, and the popular media and, of course, most non-lawyers don't understand that district court decisions, particularly in cases like this, have essentially no legal binding precedent and are really only the first step of an important set of appeals. This one will obviously clearly go. In fact, the judge stayed his decision pending appeal, so it doesn't even have literally any impact on the program itself until the Court of Appeals takes it up whenever they do. I don't think it's as slam dunk as Judge Leone made it sound. And I think that because, this may likely go to the Supreme Court at some point. If you look at the Supreme Court jurisprudence going back to the 60s on the wiretap cases and what they consider to be a reasonable expectation of privacy, I think one of the themes that gets pulled out of those cases is the Supreme Court is pretty clear that as technology makes more information public, that is to say, we're talking in public on our cell phones, or we're posting stuff on social networks and so on. The Supreme Court, there's kind of a vein in there of Supreme Court cases that say, the public's reasonable expectation of privacy changes as technology gets more information out there, whether voluntarily or accidentally. They don't have quite the same expectations anymore. And in this case, again, we're not talking about obviously private data. We're not talking about the content of telephone calls. We're not even talking about the names. We're talking about the telephone numbers, what number called what number for what duration at what time, that sort of what they call the metadata. I don't think it's entirely clear at all that the Supreme Court would agree with the district court judge here that is personal, private information in the first place. And even if so, that it would be subject to the reasonable expectation of privacy. So I hope that the NSA programs get reined in. I'm not saying I'm disagreeing with that, but I don't think this decision is anywhere near as momentous as much of the mainstream media has made it out to be.
Yeah, I haven't really been following that coverage. I've been following the more reasoned coverage from EFF and other outlets. So I haven't really, I did see, though, that it made, how this hit my radar at all is we still take the actual paper newspaper here at the house because my husband reads it. And it was on the front page of the LA Times. So I assume that it has been otherwise splashed around as a momentous kind of decision.
Yeah. I was just going to jump in and say that, yes, it is a district court opinion, and it is just on a preliminary injunction, which is, why you get that kind of qualifying language about it will likely be, because it's just a preliminary, ruling on what they might rule, what the district court even might rule once they actually have a full record. But I think that maybe the importance could be, A, public opinion, and B, what the White House decides to do as a result. And I think, some of the other stuff we've seen happen this week could also, with the release of the, special report about the, NSA and the recommendations to how to change what they're doing. I think some of that is also in reaction to this decision. So, I think it's important in that sense, that the first court to hear this and the first decision that we have in these cases that are being brought challenging the constitutionality comes out very strongly and says this is very clearly unconstitutional. And you can see that this judge, is particularly upset about what he sees happening and how it's, very detrimental and not in line with our, civil liberties in this country.
Well, I think at least the dictionary.com site is recognizing that people's sensibilities are in keeping with what Julie just said, that people are very concerned about this and wanting some definitive legal help with the program that's been going on. Dictionary.com named privacy its word of the year. Fairly interestingly, beating out other words, an interesting list of other words like sequester, shutdown, share, Obamacare, and 3D printing. Larry, do you think this is a sign of the times?
Well, if it is, it's a bad sign. Look, I have to start by disqualifying myself, because I've been saying since the beginning of the Snowden leaks that this was a story that was going to blow over with nothing actually happening. And clearly I was wrong. I was wrong about the blowing over part. I don't know that anything's actually happened yet, and I hope we'll get to talk about the Blue Ribbon Commission report in a moment. But the problem here is, of course, privacy was already a messy subject. A lot of us who spend time in Washington have, over the last 2, 3, 4 years, been kind of struggling with trying to understand privacy in the private sector capacity, what businesses could collect and how they could collect it, and what kind of self-regulation versus government regulation there should be. And quite honestly, that discussion has gone absolutely nowhere for at least the 3 or 4 years that I've been involved with it. Of course, with the NSA disclosures and the other leaks that have come out, it's now become a much more complicated topic, because now privacy is not entirely about private sector uses of information. It's about public sector uses of information. And as we know, in the United States, there's a very different legal framework in which we talk about privacy in the public sector. That's the Fourth Amendment, which does provide this reasonable expectation of privacy, but only as applied to the government. It doesn't have any real bearing on private sector uses. So when we say that privacy is the word of the year, what that signals to me is that people are even now more confused about what is and isn't private, and what law does and doesn't apply, and who should and shouldn't be regulated, than they were a year ago, and they were pretty confused then.
I think that's an apt way to sum it up. Evan, do you think that this this district court decision on preliminary injunction in D.C. Is a step in the right direction towards giving people more clarity?
It's certainly a step in a direction that many people would welcome, because it expresses a generous amount of indignation about the NSA's collection efforts. So certainly nobody is going to characterize the judge's opinion as rubber stamping the NSA's activities or being any way like having the characteristics of the FISA court that it is the subject of so much criticism here. What I find most interesting about this is the judge's recognition of a principle that I think, and maybe I have to really zoom out to a high level of generality here, because I know that commentators and scholars who really follow this, the Fourth Amendment issues here, could easily make some distinctions here. But at a certain level of generality, I see some similarities between what the judge is saying here and the effect of technological advancement, allowing the collection of so much information that it paints this very detailed picture of somebody, that the way that the law ought to treat that is different than what it used to be in the past. Talking about this case from the 1970s, the Smith versus Maryland case, where the court held that it wasn't a search for the collection of these bank records, the third party doctrine holding there. And so we see this notion of what Justice Sotomayor mentioned in the Jones case, that the Supreme Court case from January of 2012, that had to do with the Fourth Amendment and the placement of a GPS device on a car. And the court arrived at the idea that that ran afoul of the Fourth Amendment for different reasons than what we're seeing articulated here. That had to do with a property interest and actually the physical invasion of property. But what Justice Sotomayor talked about in the concurring opinion, and what Judge Leon seems to be saying in this case, is that technology now is so much different. With the NSA able to vacuum up all these records, or if you're in the UK, hoovering up all of these pieces of information, metadata, mind you, not the contents of communications. That's so much different in magnitude compared to the facts in Smith versus Maryland, that it's a difference in kind. And that because of that transformation, there's some point at which technology afforded this ability to get too much information. Who knows where that line can be drawn? But it's because of that we need to really rethink the Fourth Amendment, the way the Fourth Amendment and the interest that it creates in the individual plays into all of this. And if we are indeed beyond that line, beyond that point, which I think most of our gut reactions is, it's hard to find a person on the street who says, yeah, I don't really mind what the NSA is doing. I mean, it just seems like overwhelming public sentiment against it. If we've got to get to that point and we want to be principled in doing it, we've got to articulate, I think, where that line was crossed, so that if we're going to go forward with giving the NSA the appropriate powers to protect our national security, we establish a framework that actually is going to work without running afoul of the Fourth Amendment, without offending the sensibilities of the ordinary person on the street. Maybe that's something that this Blue Ribbon Commission that Larry wants to talk about will do, apart from any of the political currency that it would carry as well. So that's my observations on this district court opinion.
Yeah, and as you're saying, the person on the street does seem to be pretty concerned about this. And Larry, I'm as surprised as you seem to have been. I sort of thought that people would be, in one of two camps, either thought it was inevitable and an appropriate and acceptable sacrifice to be made in service of further security against terrorists, or they just didn't care. And, although I'm sure there are people in both those camps, there certainly seems to be a strong sentiment that no, neither of those approaches is okay, and we need to set some guidelines. So why don't you tell us about this Blue Ribbon Task Force, who's on it, and what they have recommended?
Right. So, and first let me say, I know plenty of people actually who are not hostile to the NSA, even as these revelations have come out, who have written pretty strongly that, what they're doing is appropriate, and the lack of oversight and the lack of transparency is necessary in order to fulfill the mission that we gave them. I'm not in that camp, but I do understand it. And I would say that, we are, as Americans, more than any other country, we're so schizophrenic in our attitudes towards this. On the one hand, of course, we have a strong national culture of preserving individual privacy that goes back to, the founding of, really the landing of the Pilgrims in Plymouth Rock. On the other hand, we also have a very strong sentiment about national security. And you may remember, it wasn't that long ago, during the course of the Boston Marathon bombing, plenty of the same people who are complaining now about the NSA, some of those people were complaining, why weren't there more cameras? Why wasn't there more surveillance? Why, sort of after the fact of a horrible activity, we always want all the data. And we are outraged that it wasn't being collected when there was clearly the technology was, existed to collect it. So, it's sort of ex post versus ex ante. We want our privacy protected, but if something goes wrong, we want to make sure that all the data that was necessary is around somewhere. And, we can do a lot better. I don't mean to suggest otherwise, but in many cases, people are asking for two of the opposite things at the same time. Just depends on when you ask them. So I want to make sure, to emphasize that we're not there. So, this report came out this week, and they don't call it a Blue Ribbon Commission. I call it a Blue Ribbon Commission because I was thinking of one of my favorite Simpsons episodes where Mayor Quimby has gotten himself in trouble again for something, and the way out of it is he announces at a town hall meeting, he's like, these allegations are very serious. I'm going to appoint a Blue Ribbon Commission to investigate them. And there's a great exchange between Lenny and Carl. Lenny says, "Did he say Blue Ribbon Commission?" And Carl says, "You can't do any better than that." And that's exactly what this commission was made up entirely of administration cronies and friends of the administration and friends of the NSA. The report is just another piece of kind of kabuki theater here, where the government is kind of going through the motions of wringing its hands about what's happened and these disclosures, without, of course, saying that they're motivated by the disclosures. The president has been, and this is not a partisan rant, because every president is equally hypocritical when it comes to these kinds of things. You're sort of caught doing something that people don't like. You want to make the problem go away. You appoint a commission. They propose, reforms that sound very serious and very severe. You don't implement any of them. Nothing actually changes. Congress can get involved. The academics can get involved. We'll scream and yell. We've been screaming and yelling most of this year. I still predict that nothing will actually change substantively, either in both the sort of the way these programs are administered or in the underlying laws. Evan mentioned the FISA court. The Patriot Act is also a big part of this. There were huge debates when the Patriot Act and the FISA Act were up for renewal and extension. All these abuses were discussed at the time. This was now 2 years ago. The press didn't really pick up on it. The Patriot Act was of course renewed, and the FISA Act was extended. And so in some ways, there's no surprise about any of the Snowden disclosures. Congress will make a lot of noise, I think, about severe reform. And there are serious people, like Senator Wyden in particular, Oregon is one that stands out as being legitimately interested in introducing more transparency and more oversight to these processes. But I'm sorry to say, I think in the final analysis, if we look back a couple of years, we'll realize nothing changed.
Wow, that is a
Denise?
depressing take on it, but it sounds like Evan was thinking you were right, spot on.
Well, I just was going to ask you, Denise, are you going to let him get away with that? It seems like every time I say anything bad about the president or the administration, you get on me. I've never called it kabuki theater, but sure do appreciate that.
Yes, well, the president and the administration have been under serious fire from so many fronts lately. I just don't know how he's going to make it to the end of the term with his sanity intact. But I must say I can't disagree with the fact that this is the way Washington works, and it's a nonpartisan thing, and it's disappointing. I think a lot of people on the Democratic side of the table had a lot of faith that it would work differently this time around, and we haven't been seeing that. So, we try not to make this a political show and get into our political concerns.
And I'm just giving you a hard time for giving me a hard time. It's well founded. I'm just looking up kabuki theater on Wikipedia now. That's all
I know. We have to make kabuki theater our second MCLE passphrase for this episode of This Week in Law. And sadly, we have to say goodbye to Julie. Julie, if you have any final comments on this or any other of our topics before we let you go, now would be the time.
No, I don't think so. Hopefully Larry's wrong. His prediction is wrong again. But I can't disagree that that point of view isn't well founded in history. So fingers crossed. Maybe it's different this time. But I'm always the optimist. But thank you guys so much for having me. I appreciate the opportunity and glad I could jump in here for a little bit. And happy holidays.
Yes, we're so thrilled that you were able to take the time out from your travels and family and give us a bit of time. And I'm very happy to have you go out on a positive note, looking forward. So we'll talk to you in 2014. Have a great holiday.
Thanks. You too. All right. Bye-bye.
Bye-bye. All right. Well, since, we're not too confident that this Blue Ribbon Commission, which I now have to say in air quotes, and love your Simpsons reference there, Larry, that it's going to be able to accomplish too much, and that it's just sort of a salve on the popular angst over all of this. Then let's move on to the ramifications of what this means to our increasingly intelligent technologies in our lives. The NSA obviously is collecting data from the technologies that we already use and that are already monitoring us in various ways. And those tendencies are not going to scale themselves back as we get into what's popularly called the Internet of Things. So let's talk about what we mean by that and what its privacy and other ramifications are. Larry, why don't you kick it off?
Sure. So, and just a nonpartisan commercial here, I'm going to be moderating a panel at the Consumer Electronics Show in January in Vegas on the Internet of Things and the policy implications. And I've got a blue ribbon panel of panelists, including Federal Trade Commissioner Maureen Olhausen, who's going to deliver introductory remarks. And that's significant because the Federal Trade Commission has sort of appointed itself the regulator of choice for new technologies. They've sort of introduced themselves into discussions about Google Glass and privacy and now the Internet of Things. And this is maybe a source of concern, maybe not. I mean, the Federal Trade Commission isn't the worst place for this, and they do have some legal authority over unfair trade practices and anti-competitive behavior. So not the worst possible thing, but we are kind of watching closely to make sure that they don't overstep their bounds, and particularly they don't start kind of regulating technologies before we've even had a chance to deploy them and figure out what they are.
Like Google
Glass. And that's the case with, sorry?
Like Google Glass, Evan
like,
said.
like
Yes,
Google
like
Glass.
Google Glass. Right. Yes. Let's ban it first and then figure out what it is.
Right.
This is so the Internet of Things is it's a phrase. In fact, a very good friend of mine, Kevin Ashton, introduced this phrase many years ago in the early days of the RFID boom I guess back in the late 1990s. And the idea here is that as computing power continues to get faster and cheaper and smaller and use less power, it becomes cost effective to introduce chips and antennas and a certain amount of data storage into other things. Of course, when he was talking about it, the idea of putting computers into telephones and televisions and cars was still a novel idea. That's now become commonplace. So the next frontier here on the horizon is to introduce intelligence into everything else, all the appliances, every socket, product packaging, so that we can start to ping them on a regular basis and ask them questions like, where are you? What are you doing? How much electricity are you using? What are you next to? And we're talking about, terabytes and terabytes and terabytes of information that can then be, analyzed, sliced and diced and used for all kinds of things, everything from energy conservation, better building management, better roads and traffic management, to things like figuring out what products are about to break and if there's sort of systemic problems that need to be corrected by manufacturers. It's really the potential, I think, in manufacturing and every other industry for a wide-scale deployment of the Internet of Things is enormous. And I don't have the imagination to even say what the really exciting applications, the real killer apps are going to be for the Internet of Things. We're just going to have to watch and wait to see how they develop as the technology just keeps getting better and faster and cheaper. The problem, of course, is that it does introduce all kinds of policy issues, privacy certainly being one of them. The idea that millions of things in our houses are kind of talking behind our backs about what they're doing. It sounds inert when you think about, well, what's that light bulb really going to say? But if you kind of put it all together in a package, depending on how you use it, it makes us very nervous, and I'm not unsympathetic to that nervousness.
It makes us nervous, and it makes us excited too. I mean, I just cannot wait until people really, manufacturers really put the smart in smart devices, that they're not relying on their users to do all the driving, as it were, that they actually can intuit things in an intelligent way and be a helpful part of our lives, rather than so frequently, a frustration where when you go home over the holidays, you spend half your family visiting time helping mom and dad troubleshoot their devices. So I definitely want to see this come to fruition, but I certainly want to see the users of these devices in the driver's seat as to, what is being documented about them and how that information can be used. Evan, anything to add to this discussion?
You can you can offer those users a seat in the driver's seat, but most people aren't going to accept the invitation to, press down the gas and drive the steering wheel, because, this is just something technology will, people will adopt this without fully understanding it. And that's just the way it's always been. There's nothing new about this, but my gosh, it just holds so much promise for so many cool things to happen in the future. I mean, the Internet of Things, and it's a little bit humbling to be talking about this with Larry, who's, studied this so thoroughly and written about it so much. But I just wonder if, there's not really going to be a definitive moment where, this is when the Internet of Things began. I mean, this is going to be a very subtle transition into these things. But even though, what was it that you quoted Hemingway saying, Larry, it happens gradually and then all of a sudden, as if there's some kind of punctuated equilibrium going on here. But I would I would take a thread from what we were talking about earlier with the NSA, and then I was kind of winding that thread in through the Jones, Justice Sotomayor analysis of this idea of privacy vis-a-vis the huge data sets that can be collected now. And I would pull it through this Internet of Things concept as well. I mean, there's just so much promise in this. I mean, little mundane things like, I actually lose a little bit of sleep over things like the water heater in my home, because, how do you get in there and really maintain that? But wouldn't it be nice if there were several IP addresses associated with that, reporting to one another to tell me something about the integrity and the functioning and the equilibrium of the water heater system, before I ever, of course, because it'll go out at the worst possible time when we want to take a shower one morning when it's 7 degrees below zero in February. So it would be nice to be able to be more proactive with those things, and you can just extend that out into the whole world. And I think it even gets cooler to meld this concept, draw the expansion of this technology even into our bodies. Just imagine having a bunch of IPv6 addresses associated with the different systems in your body. This is the quantified self. And, looking at that and getting all of this biofeedback and tying it into our environment and all the efficiencies that can be gained there and the preservation of health. But gosh, again, that thread I'm trying to tie through all of this, there has come a point already, I suspect, if justices, Supreme Court justices are saying this, and district court judges like Judge Leon are already saying this, that because of the way that information is gathered, this is a very high resolution picture of the individual that you can draw. We have to have a very different approach, a different starting point of what privacy means, whether it be in the public sector under the Fourth Amendment or whether it be in the private sector and kind of the contractual business fairness doctrines that we put into it there. The common rethinking has to come from the vast amounts of information that are available. Some of it can be invasive of privacy, some of it can be much more benign. But those two aspects, the advancement of the technology and the rethinking of the privacy, have got to go hand in hand if we're going to do this well. And I have no reason to believe that we won't be able to figure out how to do this well. We've got to stay optimistic.
Well, one person I trust to do something like this well is Phil Windley. He was formerly involved in the Utah government doing IT. I think he was the director of IT for the whole government of the state. I may be getting that wrong, but Phil is a great guy. I've known him for a few years now, and he just had a successful Kickstarter project. They were seeking $60,000. They raised almost 80 for a project called Fuse, and it is giving you data about your car. It's a kit that involves a device that gets all that information that your car is constantly gathering and makes it useful. I'm wondering if you guys have looked at this, and obviously, when Phil is someone who pays attention to these consumer-driven and privacy-driven issues. So, if someone like him is involved in trying to make cars smarter and the data useful, I have hope that, as we continue to see this kind of technology proliferate, there will be a model that puts the consumer in the driver's seat. Have either of you seen Fuse?
I haven't seen Fuse. I mean, I've sort of bought as many of these technologies as I can and brought them in the house. So I have something called the Wemo device, which you plug into a light socket, and you're able to turn it on and off with a smartphone from a virtual distance, or you can put a motion sensor in, and it sends you an email that says the cats just went into the litter box, which you can imagine could be a useful thing. I also was using some of the health and fitness ones. There's a number of companies that are making bands that essentially they're using cell phone parts, accelerometers, and sensors to keep track of how many steps you take. And eventually it'll be things like your temperature and your blood pressure and your cholesterol and how much you slept and, whether you've got apnea and all these other extremely important pieces of personal health. And I agree with Evan, actually, that I think I'm also very optimistic that we can get it right. I think there will certainly be hiccups along the way. And, one admonition to the Internet of Things industry, which really isn't an industry, but it's a lot of startups and incumbents and lots of different people working on lots of different problems, is the better job they do of regulating themselves and setting their own standards and enforcing those standards for how information is collected and used, the less there will be a hue and cry for governments around the world to step in and do it. And we've certainly seen industries with new technologies get it right. ahead of launch, and we've certainly seen them get it wrong and suffer the consequences when the government does feel that it has to step in. So I think it's still early enough that we haven't screwed it up. But there was a wonderful article, wonderful because it was terrible, a wonderful article in the Washington Post about the Internet of Things, and it was, I think the title of it was "Here's the scariest." Here's the scariest thing you need to know about the Internet of Things. It was kind of part of this tradition of imagining every new thing. The first thing we want to do is figure out the worst case scenario for it. And it was talking about how the danger of the Internet of Things is that it can be hacked because it's now part of the network, these devices, and they may not have, much, people who make your toaster don't have experience with protecting it, encrypting the data or making sure it was secure, as secure as, say, Windows 7. That it was going to be easy for people to hack in through your network, get to your toaster, you tell it to turn on, set it, to a higher setting than you wanted it to.
That's how you mess with someone.
And actually, there's already been a situation, it may be apocryphal, I never quite traced it down to see if it was real. There was a story floating around that someone had figured out a way to hack into somebody's networked baby monitor and started talking to the baby.
Oh, goodness.
Some complete stranger was talking to the baby through the baby monitor. Even if that isn't true, it is, that's not the real risk. I mean, it's definitely something that has to be addressed as well as possible, and it can be. And it's probably true that the manufacturers aren't giving it enough thought early on here. But of course, we always have to, fight against our natural impulse to be afraid of new things, especially when they come so fast and so frequently.
My favorite thing about the article is the graphic that kicks it off by someone named Charles Dyer that shows a little sticky note pointing to a toaster. Toaster was bad and set itself on fire. I can't trust it.
I think that's an Anthony Weiner reference, isn't it? Actually, didn't one of the tweets that he put out, I don't know why, I'm ashamed that I actually remember this kind of this trivia about, but like in 2009 when Anthony Weiner got in trouble the first time, he said something like because he was talking about how his Facebook account got hacked, but then he used the hashtag, "the toaster is very loyal." So I don't know if I'm reading too much into that, but
okay, no, I don't know.
I just wanted to mention Anthony Weiner. It's 2013. We're ending the year. Maybe we never have to talk about him again after 2013. So I just want to make sure we brought him up in this episode.
Okay,
that's all.
Good. I'm glad he's made it into our last show here. All right. Well, if we've throttled the Internet of Things into submission here, here I think we are ending on a hopeful note. Can I say we're ending on a hopeful note with this, Larry?
Yes.
Yes.
Unequivocally, yes. I'm very hopeful about the Internet of Things. Yeah. Some people call it the Internet of Everything, whatever you want to call it. It's probably the one technology that over the next 10 years is going to make the biggest difference positively in our economy and our social, in health, and you name it. It's got big potential written all over it.
Right. And if you're paranoid about these kinds of things, you can just always keep, one of our year 2013 toasters, or even the one from the 70s that you've probably got back in the back of your cupboards, so that it won't be networked and it will always be there to make you toast even after it's been hacked, thereby justifying the whole Battlestar Galactica story rubric that you can't have everything be connected. Let's move on to some legislation and policy stories.
Oh, yeah, Anthony Weiner. Oh, no, we're not talking about
we were talking about cars. Let's talk about cars for hire. I was watching, before we get into talking about the policy considerations about cars for hire, for anyone who has not used a car for hire service personally, doesn't know how it works and the convenience of it and the cultural currency of it, it's actually made its way onto the late night talk shows. So these services are getting some traction. There was a great Conan O'Brien segment that was promoting the movie Ride Along that's in theaters now with Ice Cube and Kevin Hart. And I just want to show the beginning of it for anyone who needs some bringing up to speed on car for hire services.
All right now I'm going to go on my little Lyft app. We're going to get us a car and have some fun. Request Lyft. I see, look at all those cars right near us.
We need to go to the weed spot. Immediately.
You have have that look, Cube. This guy, Anthony, I trust him. Look, he's got close cropped hair. Hey, Anthony, do you mind giving us a ride? I'm here with two pals. You think, oh, no time at all? Okay, great. We'll see you in a second, Anthony.
Damn, 5 minutes.
Cube,
Cube,
is this you? Do you like things to happen right now?
Like that, man.
Look, I'm not saying that I'm scared, because I'm not, but this ain't safe. We've been on the phone for some time right now, and it looks like we selling ass.
I mean, you know,
that's the look that you guys are
that ain't the look I want to put out to the world.
Hey, she's gonna try to buy anyway. We're not selling any ass, lady. I'm over here trying to buy any ass.
Wait, we have to get to the part where Anthony, not Wiener, the driver, shows up. Just a second longer. Here we go.
Hey, what's with the mustache, homie?
Do you mind if we take a ride right now? I got Kevin Hart, I got Ice Cube, Conan O'Brien here. We take a little ride and we put some cameras in the car real fast. Can we do that?
I thought this was impressive, too, how he gets a release from the guy right off the bat before they jump in.
There's a copyright comment coming up here, too.
I might have a couple ideas of where to...
Is this your own personal car?
Yes, Cube, it is.
How do you feel about people getting in funky and just funking it up?
You had people start in here.
Excuse me. Having sex?
Sex, I'm sorry.
No, but going into great detail about what it is they do sometimes.
Have you ever had to hose the car down, the interior of the car down afterwards?
There was one time when one gentleman vomited in the car, so I did have to...
Who's sitting in that seat?
You are, sir.
How did you know? How did you guys
I'm
know?
forgetting the copyright comment, Evan. Is it coming up?
Oh, it's when Conan started laying down a beat because he said he couldn't play anything over the radio. They'd have to get it cleared.
Oh, that's right. That's right.
Yeah, so.
See if we can get to that.
I'm just saying, I'd save us as much as $30. You guys don't even have to watch if you don't want to.
Have you ever got robbed?
No, not yet.
All right, mother.
Okay, this is how we do it. We get cars to pick us up. We say it's a comedy bit.
That's it.
And then we take their money.
There we go. When they start getting musical.
Yeah. You know what? I'll go. I can get us some 40s. You got to teach me how to say it, though.
Oh, no, it's a ways out.
No,
But
it's
you're
much
right.
later.
We better wrap that. But yes, he gets onto a part where they're, wanting to crank some tunes in the cars. They're riding along, and Conan goes, wait, we don't have the licensing for this, and starts, beatboxing himself to give them some.
Which I'm sure is a violation of some composition somewhere, Bridgeport.
Yes.
So.
That's all I need.
And that'll simulate us listening to some good tunes. You okay with this?
Here we
Go ahead, man.
Let's go.
See, that's totally.
Let's just talk acapella. Let's just do it without the beat.
That's not good, Conan.
Hey, did you say that was not good?
It was pretty terrible.
Yeah, that was pretty bad, Conan.
Anthony, I've known you, what, 15 minutes now?
Yes, sir.
And that's what I get? That's the kind of support I get?
Here's the kind of support you get when you real. At the end of the day, I kill. Look in my bag.
All right. I think we've had enough. But the other thing that really impressed me about that clip was Anthony, just his professionalism and the just rolling with all the craziness that was going on in his car, and what a nice service he's providing. So let's talk about these car for hire services and the fact that the regulatory framework oftentimes doesn't know what to do with them, and sometimes doesn't let them survive. You wrote about this in the New Orleans market, Larry.
Yeah, actually, I was just being interviewed for the story for the New Orleans Times-Picayune, but I had written about it, actually, an experience I had in Seattle. I wrote a post some months ago on Forbes, and immediately incurred the wrath of the Taxicab, Limousine, and Paratransit Association, which started posting hostile comments, not realizing that I could trace their IP address. And then quickly exposed that these were being, comments that appeared to be from concerned citizens about the safety of these services, and in fact they were being pumped from the Taxicab, Limousine, and Paratransit Association's actual fixed IP address, which I think tells you everything you need to know about this story, which is we have had however many decades of highly regulated transit services. There were many reasons for why regulations came into place in the first place. Here, as in other industries like hotels, which is another one that's under siege from the internet. But it's clear that after all these decades, these are industries that do not have any idea how to innovate. They have no incentive to introduce new technologies. You get into a taxi cab, maybe the radio works, and maybe it's an AM radio. Maybe they've got, very, very basic communications back with their dispatcher. But the idea that they would have, GPS navigation, that they would be able to be ordered and dispatched and paid for using a smartphone app, all, as I said in that the New Orleans story, completely mundane technologies now, right? There's just nothing that's fascinatingly innovative about these services, Uber and Lyft and Sidecar. That is to say, the technology they're using, they're just using the smartphone network and they're using apps. That's the basic thing. The real innovation is figuring out, there could be a better way, a more efficient way and a more safe way, and just a nicer experience for people who want to hire a ride. And the response of the Taxi Cab, Limousine, and Paratransit Association is to say these are rogue apps. They've got to be stopped. Using technology, that's a bad thing. We wouldn't want to do that. That somehow would be harmful. So instead of competing, they just want to stop it.
So where do things stand in New Orleans right now and in Seattle, since you had personal experience about that?
Well, Seattle. So Uber is well established in Seattle. That was the service I was using in the article. And many cities around the world, not just in the United States, Uber and Lyft and Sidecar and some of these services, they've had ups and downs with the regulators, and they're still fighting these battles. Actually, in New Orleans, the joke of that story was that they weren't even there. They had just put an ad in the paper saying, "Are you interested in the service?" We're, kind of test marketing what the level of interest might be. And they immediately got a cease and desist letter from the Taxi Cab Commission of the city of New Orleans saying, stop advertising your service, stop operating your service. If you are operating a service, whatever you're doing, we don't like it.
So do we know if that's going to be the end of things there, or,
No.
It seems like no.
No.
So,
whether they understood this from the beginning or not, I think these services have figured out that their main marketing activity is to market from a regulatory standpoint. That the social media is spreading the news about how useful and nice these services can be and how much more effective and efficient it can be. But they have become very quickly adept at understanding the state regulators, the local regulators, sometimes county regulators that they have to deal with, and in fact are being very good about using their customers kind of as bulwarks to go to the regulatory commission meetings and say, don't shut down this service. We like this service. Whose interest are you supposedly protecting here? You're supposed to be looking out for consumers. It sort of looks like you're really protecting the interests of the companies you regulate and have been regulating all these decades. Why are you trying to protect them when you're supposed to be protecting us or advancing our interests? And the regulators, this happened in Washington and also here in California, but in Washington, the district council commission shut down the services. And then there was a meeting and all these people showed up. I mean, actual, citizens showed up, which has probably never happened before at these regulatory commissions. And the commissioners just freaked out. They had no idea what to make of actual constituents appearing. And so they quickly reversed themselves on the car sharing services. And the same thing happened in California. Now, in fact, they've said they're okay, and they're going to kind of rewrite the rules to make sure that it's clear in what ways they are and aren't regulated. But there've been a lot of these cases where they've gone in, they said, we're not a regulated service, we don't have to abide by the regulations. The regulators have shut them down. And then they've gotten a dramatic reversal when their customers show up at meetings and say, we think you're protecting the wrong people.
All right, Evan, on the last couple of shows, we've had car safety come up in different iterations. We have it again here because presumably the argument in favor of regulating transport services is safety. So you have some consistency for the quality of the vehicles, the maintenance of the vehicles, the training and proficiency of the drivers. So you've got all of those concerns coming into play to perhaps put some controls on these car for hire services that are springing up all over the place. Obviously, I think we would all be in agreement that we want to encourage that kind of innovation and competition. But do the people on the regulatory side have a point?
Well, I mean, you don't have to use a whole lot of imagination to see what the real public safety issue is. I think each of us has to ask, would we want our spouse or our son or our daughter getting into a car with some random stranger? It kind of boils down at a very I'm oversimplifying it, but that's pretty much the real question there. So, the least cynical part of me looks at the regulators' responses to this and what Larry was characterizing as them standing up for the incumbents in the industry rather than the public interest is hopefully that's just something that they're actually standing up for the public interest by proxy, doing that because we want to make sure that the network, for lack of a better term, the fleet of vehicles that takes people from point A to point B in an urban setting or what have you is reliable and safe, and that the people that are behind the wheel are competent and not creeps or criminals or what have you. So I don't know how to answer the question, and I'd leave that to the smart people who actually are the regulators, who are. It's their job to figure this all out. But when it just goes back to the essential point, the essential issue, Denise, that you're bringing up here, it doesn't. It's very easy for us to recognize where the public safety issues are when we start talking about cars, because they are, made of metal. They weigh a couple tons. They go fast. They can really injure someone. They can really hurt someone in any number of ways. And so we've really got to be careful when it comes to that. There's an immediate safety concern, and it's unfortunate that a lot of these issues get. They're freighted with cronyism and nepotism and the old boys club, at the local regulatory level. So it's unfortunate that it gets kind of mired in that.
Yeah, Space Q in IRC is making a good point on this front, that the private sector is actually trying to take care of those public sector kind of concerns when it comes to these services by providing ratings for the drivers, so that if you were sitting there, you were Conan and Ice Cube looking for a ride, you could see.
We all know how reliable those are. I mean, every review on Yelp, 100% accurate. Every Amazon review I've read, 100% accurate. So yeah, I would trust my life with that, sure.
Well, and again, I mean, as far as trusting your life or your family's life, maybe you do have some controls, again, coming from the private sector and not the public one, in place over, if your kid's running around town, whether they can take a Lyft car or not. But, I would push back on the rating issue. Sure, some of them are faked and inflated, but by and large, I have really good experience with going to well-rated businesses. I find, the ratings and the service and experience that I have there tend to match up.
Yeah, but the cupcake shop is not driving you down the road at 45 miles an hour and taking you into secluded places at under cover of darkness.
That's true.
So, a couple things. First of all, one difference between Yelp and these services, of course, I'm only going to speak about Uber, and not because of commercial for Uber. This is the only one I've used. Is you can't rate an Uber driver unless you've actually transacted with that particular driver. So it's not just it's not possible or not as easy to sandbag as it might be on a service like Yelp, where anybody can review anything. The other thing to point out is it would be nice if Evan was right in the sense that what the regulators were talking about was safety and the things that we do care about. In the case again of the Uber limousine service, there's no issue in there, because they only actually what they're doing is just dispatching already licensed, already insured, already regulated limousine drivers. So these are people who are fully under the control of the regulators anyway. This is just an alternative dispatching system for when they're not otherwise occupied. They can take an Uber job instead of a job from their normal dispatch. And so the fight is really over, who gets to do dispatching. Whatever you want to think about that, there's no safety issue there. These are the same cars and the same drivers that you would be getting if you went through a quote unquote licensed dispatcher. The other thing is, a lot of the times the regulations that they get shut down by have nothing to do with safety, and this was true in Miami and also in New Orleans. For example, one of the rules in New Orleans is you cannot get a limousine unless you order it. I think you have to order it at least 48 hours in advance, and the minimum fare is $70. Now, that was obviously a rule that was put in place to keep limousines from doing the work of taxi cabs. So essentially to separate those two businesses. They probably, kind of agree to kind of mutual protection of their turf. But you can't imagine how that's helping consumers any. If a consumer says, well, I want a limousine and I don't want to, I want to order it now and I don't need to pay a $70 minimum fare if the fare is less than that, there's no protection for consumers in that kind of regulation. It's purely for the benefit of keeping the industries, protected from each other or from new entrants. That's unfortunately the kinds of things that is going on in these fights over these new services. It's not about the things that they ought to be caring about, which is safety of the vehicles and the drivers and things of that nature.
All right. Either of you have any other comments on car for hire services and their future and present?
I love how this issue can, elicit a bunch of cynicism, because I could say, no, that's the $70 limousine thing is to protect the 1%ers. God forbid they have to ride in a taxi. We want the status of a limousine. So it is in the consumer's interest, just that 1%.
Yes, there you go. All right. Well, since we've been talking about reviews, let's move on to a couple of stories related to the social web. This is a story that one of our listeners tweeted us. Thank you so much for that. We do appreciate it when you let us know when you see things that you think we should discuss on the show. This involved a Utah couple that gave a negative review regarding a Christmas order. So in keeping with the holidays here, they had a botched order from a company called Clear Gear. And they gave Clear Gear a negative review in light of their experience. And they were then fined $3,500 for writing that review. How did anybody have the authority to fine them, Evan? I haven't dug too deep on this yet.
Well, I suppose that's an open question. It was a term, I think they were saying it was in the terms of service when they bought product that they agreed not to do this. But I think that's a question of fact, whether the terms of service even said that. And clearly the more interesting legal issue is going to be, under the analysis of liquidated damages. But yeah, terms of service is where the genesis of the point is.
Mm-hmm. So they're being sued to collect that fine. That is, may or may not have been sufficiently stated in the terms of service. And let's see, Jen, and actually they are suing the company that they gave the negative review to, saying that acting in this way violated the Fair Credit Reporting Act, was defamatory to them, and inflicted them with emotional distress and other things. So
yeah, you got to love the sensationalism here, because they're saying that their credit was ruined because this company tried to fine them, and when they didn't pay the fine, they turned it over to the credit reporting agencies. So you got to love the sensationalism here. They said they couldn't qualify for financing to fix their home furnace. If it'd been on the Internet of Things, they would have known their furnace was going to break, by the way. But and so you love the creative plaintiffs' lawyers in this, talking about how they had to wrap their son in blankets to keep warm because they couldn't get the home, the furnace fixed. And I mean, I don't want to giggle at somebody else's.
It's chilly there in Utah.
Right. I don't want to giggle at anybody else's misfortune. That's the last thing I want to do. But you gotta love the extremism and the way that this stuff is being pled and played out in the public here. They couldn't finance the furnace. They were delayed in refinancing their home. So, essentially the whole world fell apart because of this negative review that they left on Ripoff Report. So I think both sides are probably guilty of a little bit of exaggeration, but not to diminish the fact that I'd be pretty ticked off too if a company tried to fine me $3,500 for just speaking out. If indeed the facts are the way plaintiffs are saying they are, and we all know that always happens. And there is plenty of things to be upset about for these folks.
Yeah, certainly. I mean, I would certainly get ticked off if a company tried to fine me for writing a negative review, and I would be ticked off if they then tried to smear my credit. Yeah, which points out the problem that it's far too easy to do that. Larry,
that's
what
why
do you
we
think?
have.
Yeah, that was. I mean, I don't know. Maybe I'm maybe I'm not as cynical as Evan is. I fell for this story hook, line, and sinker. I thought this, I believed everything that the plaintiffs were saying in the write-up, and I thought this is, one outrage after another. And apparently, the terms of service that had this non-defamation clause in it, which of course no one is going to have read anyway, wasn't even added until after the transaction was done. So even if it was enforceable, it wasn't even part of the terms of service when they made their purchase. But yeah, that the company would go to the extent of sicking sicking debt collectors on them and putting bad items on their credit report and not cooperating with efforts to remove them. If it all turns out to be true, it's unbelievably not only outrageous, but so stupid on the part of the company, because they are going to get such bad publicity from this. And it does point out, I think, you've had Eric Oldman, of course, on the show many times before. This is an area that Eric has really written about, particularly is this idea of, it's not just, websites, but of course, doctors and lawyers and other professionals in particular are trying to shut down negative reviews. Of course, they may be factually correct negative reviews, and they're using, all kinds of sneaky tricks and agreements and documents that may or may not be enforceable, but certainly aren't understood by consumers when they sign them, to say, no matter what I do, no matter how bad my service is, no matter what kind of harm I cause or injury I cause, you're going to agree ahead of time that you will never speak of it in public, and you will never tell the truth about it. And that, of course, deeply offends our sensibility of the marketplace of ideas and the free flow of information. That the way in which markets work is if consumers can tell each other what's good and what's bad. And if they can't do that because bad people want to make sure that bad information about them doesn't get out there, in some ways, capitalism itself fails. So if I was writing this complaint, Evan, I would have gone much further than the furnace. I would have said that the very heart and soul of capitalism and Adam Smith was on trial here, and that if this company wasn't stopped in its tracks, our entire system of government and economy would fall to its knees.
It still might. This does represent a deeper problem. Hey, if I heard you right, I think, are you and I in a competition for being cynical? Because, man, if so, I am playing in the big leagues. This is great. But
yes.
But yeah, I mean, there is a theme here. Going back to the very first thing we were talking about when I was raising that point with Julie about private censorship here, and I think this is a confusing issue because, again, and I broke a vow I made to myself early in the show when I was talking to Julie, bringing up the whole Duck Dynasty thing, because, man, that is a tricky issue, and I don't want to even come close to talking about the merits of that. But it's just like we everybody gets so indignant about free speech. I'm saying free speech, not First Amendment. I'm talking about free speech, because free speech as a norm, even if it's a private actor. But what is the standard? Where is the baseline on all this? And, how are we ever going to make it anything more than just an ideologically based approach as to what is good when we make rules, societal norms about when we're entitled to shut each other up? I imagine it's a timeless question, and it's probably totally vain to even try to resolve it. But where is the role of? And this is totally a rhetorical question. Where are we going to assign the role of free speech in our society from a normative point of view? I think this is just another example of that.
It doesn't have to be totally rhetorical in the context of what we've just been discussing, because certainly where there's a strong public safety and health interest, then the speech is going to be, even more important from a policy standpoint. And we've been talking about the importance of that with cars and doctors, and I suppose even these home share kind of outfits. If you wind up staying in a place that's unsafe or maybe unsafe to you in some way, because the people who have gotten you there, now have you in their clutches. There's a pretty high interest in making sure that doesn't go beyond creepy to dangerous, and that reviews are a really big part of that transaction these days.
Well, I still don't know where the line is.
Yeah. No, I don't know where the line is either, but I think that, public safety is a big part of, it should be a big part of the analysis.
Yeah, no, we
Go ahead, Larry.
won't know where the line is, but I think, Evan, you're on the right track in asking these questions, because the reason it's becoming more urgent to us is the technologies that we've got and that we're getting in the future. In essence, what they're doing is they're generating more interactions between people, between individual consumers and other consumers, between people and companies, between people and their governments, between our devices and our other devices. And those transactions all operate under, a sort of a assumption that there's a free flow of information that makes them possible. And so I think why you're asking that question is because it becomes more urgent as we have more of these opportunities to interact, to ask, well, what's an appropriate kind of interaction? And in many cases, we're on new terrain where clearly the technologies get ahead of our social norms and certainly ahead of our legal and regulatory systems. And so if anything, what you can predict is we'll be asking those kinds of questions in very specific contexts much more frequently in the coming years than we did 50 years ago when there was just much less going on.
Yeah, it's almost like that we as individuals haven't yet come to terms with the responsibility that we have, given to us by the forms of communication and the means by which we have to express ourselves and to, gather a community around us and then, shut a portion of that community out. So, and then on top of that, norms themselves are changing as to what is acceptable to talk about. There are certain things that would have been totally fine for me or anybody, not just me, a person to say publicly in the 1950s, where now you would be metaphorically driven out of town. So.
Well, and the opposite is true. I mean, think of the first, the couple of minutes that Denise showed of that clip of Conan and the two comedians. I mean, some of the things that they were saying, even whether they were bleeped or not bleeped.
Yeah.
20 years ago on television, you couldn't say any of those things.
Right. I didn't get most of those jokes, so maybe after the show you can explain them to me.
Right. But they were kind of pointing out, too, some of the public safety concerns. Is this safe? Are we standing on a safe corner? Or is it going to be safe when we jump into the car with this stranger? We don't know. They were making a lot of fun of it, but they were voicing some legitimate concerns. Let's move on to our tips and resources for our last episode of 2013 of This Week in Law. I was a little bit intimidated, I got to say, coming up with a tip that would, end the whole year and give you something concrete that would just sort of make your life with law and technology all the better. I'm afraid I didn't really rise to the challenge, but I was able to glean a tip out of something that Larry tweeted earlier this week that's really more of a resource. So we've got a lot of resources here. Let's see, I just lost my link to it. The Year in Tech Quotes from PC World magazine. And my tip comes from one of the quotes highlighted there from Adam Thierer when he was testifying before a U.S. Senate hearing about targeted advertising. My tip would be, I guess, and it's in keeping with our discussion on the Internet of Things and needing to be cautious with regulation, don't fear the creeper. And what Adam had to say was that it's hard for me to find real harm with creepiness, he said. I think a lot of my neighbors are creepy, but I don't think they're harmful. So I guess that's that line we were talking about of when regulation is necessary, and Adam here was trying to help the Senate even understand that. This was a pretty funny list, Larry. I was happy to turn this up in your Twitter feed, so I hope people enjoy it as much as I did. Any other favorites here that you wanted to highlight?
Oh, I looked at it again this morning and I could remember there were some good ones, but yes. I will say Adam is on my panel in Vegas on the Internet of Things, so hopefully he'll come up with more bon mots for us to quote.
Right, and further elaborate on the creepiness factor. Let's get to some resources for the end of the year. One of them, holiday themed, is if you're interested in doing any Christmas caroling or recording any Christmas music this season, Time Magazine has a little highlight of a little infographic and piece on why Silent Night will never go quiet. It and many other holiday tunes are in the public domain. And, this all kind of ties together. Time Magazine did this sort of deep data dive at the U.S. Copyright Office, which offers digitized registrations going back to 1978, and looked at the collected data on every Christmas album recorded since that time, found that Silent Night is not just the most popular Christmas carol. It has 733 copyrighted recordings since 78. It's almost twice as dominant as the next one in line, which is Joy to the World, with 391 records to its name. So interesting there on, how things in the public domain continue to have a life, particularly around holiday things. And then also there's an article from the Rights Workshop. This goes back to 2010, but is timely and related. 10 Christmas songs you thought were in the public domain but aren't. And it gives you a little rundown of various, also sort of timeless classics that you might have thought were old enough to be in the public domain, but such things like Winter Wonderland, Have Yourself a Merry Little Christmas, White Christmas, I'll Be Home for Christmas, and there are more, are not in the public domain for various reasons that are described there. Not done with the resources for you yet. Great infographic. Again, this is something Larry tweeted earlier. We talked about new developments in the Aereo and Film On litigation last week when Aereo declined to oppose the Supreme Court granting cert in one of its various disputes. It said basically, as TechCrunch reported, bring it on. Let's get this issue in front of the Supreme Court. But over at DISCO, the Disruptive Competition Project, they have a truly awesome infographic, and an infographic was really needed to understand what's going on in all the various cases that involve Film on X and Aereo, and what the ramifications of those are for Aereo being able to do business around the country. So that's a cool little resource if you're interested in that litigation. And then finally, EFF, I'll just leave you with a great resource to kick off your holiday break, assuming you're taking one. Some perhaps books that you might want to buy last minute for people on your list, or things to hunker down with when you've got some time to read. EFF has a reading list of the books of 2013, with books by Marvin Amori, who's been on the show here on Internet Freedom. Cory Doctorow's on here with his book Homeland. A bunch of other things. I have not read anywhere near all of these, but would love to get through them all. So, and of course, Big Bang Disruption, when it is officially available and out of the pre-order phase, should be on your list as well. So with that, we're going to go ahead and wrap up the year, call it a year. This has been a really fun way to end our year with a great discussion with Julie-Ahrens, who was with us previously on the show today, with Larry Downs, who's one of our all-time favorite guests. And Larry, just keep coming on the show. Will you please promise me you'll do that? Because it's so fun whenever you come.
Sure. If you keep plugging my book. No, it was great. And I this has been a really fantastic year for me and for tech policy. It's just been more fun than ever. So I always love coming on and talking to you guys. And I'm delighted to be here at the end of the year to wish you all a happy holidays and a really big bang next year.
Yes, thank you so much, and best of luck with the book. And of course, if you're interested in following along with discussions around Larry's book, etc., you can find him at larrydowns.com and on Forbes. And Larry, as we've been joking with him, is not one to not give you a lot to read. There's definitely a lot to go deep with around not just the book, but the conversations that spring up from it. And you're great, Larry, in using the medium to just continue the conversations that get started in your original work. So we appreciate that, and we appreciate you being on the show, and wish you the happiest of holidays as well.
Thank you very much.
Evan, I can't believe we're going to not see each other for a couple of weeks. You know, I'm going to miss you. Have a great time with your family.
Well, thank you. And the same to you. Have a great holiday out there. You know, it's been a great year, 2013. Lots of interesting stuff to happen. Yeah. So I've sure have enjoyed, breaking it down with you every week, every Friday like this. Thanks for keeping me around as your sidekick on the show. Really, really love it.
So. As though that's even, a consideration.
Oh, shucks.
Yes, I would have to just schlep myself to Chicago and start banging down your door were you to tell me that you weren't going to be around. So that's just not even a thing. So I'm just thrilled to always get the chance to chat with you and butt heads from time to time, and even more importantly, get each other's disparate perspectives on things. I really love how we're able to bring our own experiences to the show, and that they're not the same experiences at all. So,
right. I enjoy it too. So looking forward to 2014. It'll be a good time.
Me too. And we couldn't do this without all of you, the listeners. Alex, I'm not even sure if the Twit survey is still going on, but I'm going to go ahead and plug it. You can jump in and tell me, no, it's done. We're not going to take any more information if that's the case. But assuming that's not the case, there is a survey at twit.tv/survey where you can go through and answer some questions about this show and the other shows on the network. It's completely anonymous. It's just to give us some information about how we're doing. And we'd love to hear from you. We hope we're doing well. We want to hear from you not just there, but also in all the various social media avenues that you might be using. We're on Twitter. Evan is Internet Cases there. I'm D. Howell over there. We love hearing from you in email. I'm Denise at twit.tv. Evan is Evan at twit.tv. And we love hearing from you on our Facebook and Google Plus page as well, which give you a little bit more room to expand on those ideas that you're trying to share with us rather than trying to cram them into a tweet. So we're glad we have all of those media available to us to interact with you. We love interacting with you live during the show. We record every Friday at 11 o'clock Pacific time, 1800 UTC. We will be dark for the next 2 Fridays, but we will see you in the new year when we pick things back up. So we hope you'll join us live then. If you can't join us live, then find us on YouTube, perhaps. We're over there at youtube.com/thisweekinlaw. That's a real easy way to get to our most current shows. And the full archive of shows is available at twit.tv/twill. So head on over there if you need to go back and bone up on some of Larry Downs' great appearances on the show when Julie-Ahrens was on back in May, etc. We are so blessed that we have so many great people who will come on and help us understand these really important and difficult issues and help us shape our thinking on them, because the way we all think about them is ultimately how law gets made. So don't forget that. Keep your thinking caps on during the holiday, and we will see you in 2014. Take care, everyone.